Hi, I'm Don Hubin, the chair of National Parents Organization, and I want to talk today about the barriers to having presumptions of equal shared parenting and how to overcome those barriers. Let me start with just a little bit about myself. In addition to being the chair of the National Board of National Parents Organization, I'm also a professor emeritus of philosophy at the Ohio State University, and I think there's some kind of penalty we get if we don't say the when we describe Ohio State University there. I'm a founding director emeritus of the OSU Center for Ethics and Human Values, something that I'm very proud of. But most relevant to today, I am the father of 3, stepfather of 2, and the grandfather of now 6 children. And I want to be just about as brief in saying something about National Parents Organization. NPO is the nation's largest and most effective shared parenting organization. We have chapters in 26 states, and we work not only with our chapter affiliates, but with other organizations in those states and in other states to promote shared parenting across the United States. I describe National Parents Organization as being a child-focused and research-based organization. And what I mean by that is that we ground our advocacy for shared parenting in the very best research available about child well-being. Now, we're going to go on for a little while today, and so I want to give you an outline of what I'll be talking about so that you can keep track of where we are in the presentation. I want to begin by just getting down some basics about shared parenting, some key definitions. For most people, this will be redundant. People know this, many people know this, but I want to make sure we're all talking about the same thing when we talk about shared parenting. And then I want to talk about the benefits of shared parenting for moms and for dads, and especially, of course, for children. These benefits are so pronounced that it's surprising that shared parenting isn't the presumption everywhere across the country, but it isn't. And it isn't because there are barriers to shared parenting. I want to talk very briefly about institutional inertia. People have to understand that there are structural problems that can make it difficult to enact presumptions of shared parenting. But most importantly, there are special interests who are generally aligned against presumptions of shared parenting. These include many judges and judicial associations, many attorneys and bar associations, and domestic violence groups. And I don't want to paint with too broad a brush here. There are certainly many judges who support presumptions of equal shared parenting, as there are many attorneys, and there are domestic violence groups who are supportive of shared parenting as well. But by and large, when presumptions of shared parenting are introduced into the legislatures, we can often predict that we'll have opposition from one or more of these 3 special interest groups. Another barrier to presumptions of shared parenting, and a barrier to people actually doing shared parenting, is outdated and poorly designed child support laws. And National Parents Organization has taken the lead in doing research on this and how to design child support policies so that they promote rather than hinder shared parenting. And then, if we have time, I'll talk about some of the myths that surround shared parenting and debunk these myths. Then I want to turn to the more positive thing of what we can do to overcome these various barriers to presumptions of shared parenting. And we'll see that this falls into really 3 categories. One is education of divorced professionals, judges, attorneys, custody evaluators, and so forth, and education of parents. And then there's also legislative reform, changing the laws that govern custody. And finally, changing court practices and court rules, because courts are guided not only by the statutes, but also by their own court rules and by the practices that they've entrenched there. And then I'll just mention a little bit about the tasks that lie ahead of us if we're going to get shared parenting to be the typical way that separated parents handle the raising of their children. So first, some shared parenting basics, some key definitions. There are 2 elements of shared parenting. One concerns legal custody, and the other is physical custody. Legal custody refers to the decision-making responsibility with respect to the children. Who has the right to decide the children's religious upbringing, their education, their medical treatment, and so forth? Physical custody has to do with the placement of the child, with whom is the child or are the children living. Now, in a sole custody arrangement, these are combined. So the same parent has both legal custody and physical custody. But these are two distinct elements, and they can come apart. So parents can share legal custody of their children, the decision-making responsibility, but not share physical custody of the children. And that can happen especially if the parents live far apart. That may make it impossible for them to share physical custody, but there's no reason why that means that one of them shouldn't have a role in the decision-making responsibility for the children. And conversely, parents can share physical custody, but not share legal custody. And that's something that arises sometimes when the parents live close enough to share physical custody, but they are locked in sort of irresolvable conflict about some question about what religious upbringing the children have or medical treatment or something like that. And in those cases, the courts will often say, while these parents can share physical custody, only one parent has legal custody. The point here is that these are separate concepts and they can come apart. Now, shared parenting refers to the situation where parents have joint legal custody, so each parent continues to have decision-making responsibility with respect to the children, and they also share physical custody or parenting time. How much sharing of physical custody is necessary to call it shared parenting? Because even in a sole custody arrangement, very often the non-custodial parent has visitation, is the old word we used to use for this, has visitation with the children every other weekend and one evening a week. And that can actually add up to 18, 20, 22% of the time, depending how summers and holidays are divided and so forth. Researchers into child well-being usually define shared parenting as an arrangement where the children are in each parent's care at least 35% of the time. Now, that's an arbitrary line. Obviously, there's no significant difference in the experience of the children if it's 34% of the time or 35% of the time. But just in order to do research on the outcomes for children, you have to draw a line somewhere, and researchers typically draw it at 35%. Now, at National Parents Organization, we talk mostly about equal shared parenting. And what we mean by that is a situation where both parents continue to have the joint legal custody of the children, and they have substantially equal parenting time. Sometimes people worry about whether this means, minute for minute equal parenting time. That's not really what's important. What's important is that both parents are equally involved and there's substantial equal parenting time. So it's not worth arguing over an hour, but it is worth arguing over whether or not both parents are involved in the sort of ordinary parenting activities of getting the children to do their homework at night, getting them to bed and off to school, and all those ordinary things that constitute parenting. So that's what we mean by shared parenting. That's what we mean by equal shared parenting. What are the benefits of shared parenting? Well, we believe that shared parenting is a win-win-win arrangement. And what we mean by that is it's better for dads, it's better for moms, and most importantly, it's better for children. So let me talk about each of those briefly here. Being marginalized, or in some cases completely erased from their children's lives, which is something that happens to both men and women, but much more often to men, to fathers, that harms men's health and well-being. And I think as a background piece of information, we need to recognize something that isn't fully appreciated, and that, two researchers put it this way, is this: a man's life as his father is central and not peripheral to his health. So your relationship to your children is not something that is a nice add-on to your well-being. It is really a part of father's well-being typically. And so the problems with men's physical health, this includes fatigue, sleeplessness, back problems, and a number of other issues, those increase with worries about their children and their parenting relationship with their children. Well, what does that mean for divorced fathers who wind up in the typical non-custodial track? Dr. Robert Fay reports that the typical non-custodial father is buffeted with feelings of grief, loss, anger, and failure. He experiences increasing desperation as he now begins to appreciate the depth of the gulf, physical and psychological, that now exists and is widening between him and his children. And as researchers Deborah Umberson and Christine Williams conclude, the strain associated with the parental role may be one of the most important factors contributing to the distress experienced by divorced fathers. Two other researchers, Jeffrey Grief and Mary Pabst, conclude apparently many fathers, like mothers, give up custody reluctantly and feel ambivalent about it. It is difficult for them to separate from their children, even though it's the norm. We may need to rethink many of the normative views that we have about men suffering less than women when they are separated from their children. Just because their non-custodial status puts them in a fairly large group with other fathers, this does not mean that it's a comfortable role for them. Perhaps the most poignant measure of the distress that many divorced fathers experience shows up in suicide statistics. And Dr. Agustin Pessoa found that divorced fathers are victims of suicide almost 2.5 times as frequently as their married counterparts, and they're victims of suicide 10 times more often than divorced mothers. And I think, given the fact that fatherhood plays such an important role in men's lives, it's probably not coincidental that fathers are about 10 times less likely than mothers to get sole custody of their children. Well, that indicates some of the benefits of shared parenting for fathers. It allows fathers to continue to engage in their traditional fatherly role, to have a full relationship with their children, not to suddenly be sidelined and treated more like a kind of uncle that sees them on every other weekend. What about the benefits for mothers? Well, when one parent, and that's usually the dad, is marginalized in the children's life, the other parent, usually the mom, is overburdened. And we see tons of research about the stress that single mothers experience trying to juggle being a mother and having a job and so forth. Shared parenting allows moms to further their education, to advance their careers, time to decompress, which anyone who has children knows is important, and to develop their personal life, to date, to develop another relationship and so forth. The message of the benefits for moms is something that is trumpeted by the organization Moms for Shared Parenting, founded by Emma Johnson. She focuses on how shared parenting really produces a much better outcome for mothers. And in pursuit of that, she did a survey of single mothers, over 2,200 single mothers. And here's what she found. Mothers who have 50-50 shared parenting are 54% more likely to earn at least $100,000 a year than mothers with primary custody. And they're 325% more likely to earn at least $100,000 a year than moms with 100% physical custody. Well, why is that? Well, remember I said one of the things that shared parenting does is to allow moms the time to pursue their career. And Emma Johnson's survey also found that 9 out of 10 single moms say they could earn more money if they had more equality in parenting time. 53% of moms said that they either enjoy 50-50 schedule or they wish they had it. And moms with 50-50 parenting are 34% more likely to say they feel awesome and proud of being a mom compared with the moms who care for their kids 100% of the time. And this just goes back to the stress that single moms often feel and the fact that they don't have the time to decompress, to take care of themselves away from their children. Okay, that's enough on moms and dads. What we really care about here, we care most about anyway, I guess we care about all of this, but we care most about is the benefits for the children. And here in putting together this presentation, I had a difficult task because we have more than 40 years of research that speak as clearly as social science research ever does to the conclusion that when parents are living apart, it is almost always best for children for them to have significantly equal time with both of their parents. And that's true regardless of the parental income or educational levels. It's true even when the parents don't initially agree to shared parenting, when one of them has to be sort of pressured into accepting shared parenting. It's true even when the parents are in conflict, in nonviolent conflict with one another. And it's true even for infants and toddlers. And it turns out the closer the split in parenting time approaches 50-50, the better it is for children, because it reassures the children that neither parent is in a subsidiary role. Both parents are there for them and support them equally. Neither one is sort of a minority parent. I just picked a few quotes from some fairly recent research that summarizes these results. So in a 2018 paper, what the researchers found is that children in joint physical custody have better mental health and fewer behavioral problems than children in sole physical custody families. And more surprisingly, they said, results from several Swedish studies are that there are no differences between children in joint physical custody and nuclear families in regard to emotional or behavioral outcomes. That is to say, the children do in shared parenting arrangements in Sweden do just as well on these measures as children in nuclear families. There was a really remarkable paper published in 2023 by Professor Laura Vowles and her colleagues. And what they did was to identify 39 high-quality studies on the outcome of children in different living arrangements. The outcomes that these different studies measured included emotional, behavioral, relational, the relation with other siblings, with parents and other relatives, the physical health, and the educational attainment of the children. The overall findings were this. A total of 29 of the 39 studies suggested that either there's no difference between children's outcome in nuclear families and shared physical custody arrangements, or the differences go away after certain explanatory variables. In contrast, in as many studies, the results showed that children in sole physical custody arrangements showed worse outcomes compared to nuclear families. And then what about young children? Because I mentioned that shared parenting is appropriate even for infants and toddlers. Well, here's what Professor Vowles and her colleagues found. Although only a small number of studies included exclusively young children, all studies except one showed that children in nuclear families and shared physical custody families had equal outcomes. In contrast, children in sole physical families had the worst outcomes in 4 of the 6 studies. Now, there's a moral to be learned from all of this research. I've only touched on a few research articles here. There are literally scores of articles that come to the same conclusion. And the moral that comes from all these is this. The ill effects that we know children of divorce experience are due largely not to parental separation, but to parental deprivation. It's not the fact that the parents have chosen to live apart that is causing the most harm to the children. It's the fact that we choose to have a system that means that when parents are living apart, one of them is going to be sidelined in the children's lives. So we have research that shows that shared parenting is best for children. There's research that shows that it benefits moms and it benefits dads as well. We also have public polling that shows that the public overwhelmingly supports presumptions of equal shared parenting. National Parents Organization has funded independent polling in now 26 states, and we're getting ready to conduct polling or to have polling conducted in another 5 states across the US. And what we found is that in every state, the support not only for the practice of shared parenting, but for there being a legal presumption in favor of shared parenting is over 83%. We live in divided political times. That's not news to anyone. It's hard to get 83% of people to agree that apple pie and motherhood are good values. But at least 83% of people in every state that we polled support shared parenting, and there being legal presumptions of shared parenting. And when you dig down into the data, we see that the support for shared parenting cuts across every demographic divide. It cuts across race, ethnicity, age, religion, income, political affiliation, and sex. This is truly an issue that can unite Americans of all political persuasions, all religions, all ethnicities, and all races. And here's a map that shows the states in which we have funded this polling. And I want to emphasize, this is not National Parents Organization calling up and asking people if they support shared parenting. The polling is done by an independent agency that asks people about their attitudes about shared parenting and shared parenting laws. We've done it in 26 states. On our website, we have this map. In the dark states, if you mouse over the state, you will see you'll see a summary of the polling in that state, and you'll have the option of downloading a one-page handout that summarizes the polling there. Looking at this map, you'll see that the support for shared parenting is in large states and small states, in liberal states and conservative states, in states that are predominantly rural and states that have large metropolitan areas. It just cuts across America. Now, if the research says that this is best for children, for parents, and parents want it, why isn't shared parenting the law of the land in every state in the country? Well, because there are barriers to shared parenting. And the first one I just want to talk about very briefly. The first is institutional inertia. Then we'll spend more time talking about the special interests that oppose presumptions of shared parenting and the outdated and poorly designed child support laws, and then some myths that stand in the way of shared parenting. I won't say much about the barriers to shared parenting. It's obvious once it's pointed out, I think. The United States is a union of 50 states and the District of Columbia, and family law is almost exclusively state law. And that means there are 51 separate jurisdictions in which battles for presumptions of shared parenting have to be fought. And that by itself is a significant barrier to getting nationwide presumptions of shared parenting. Legislators have a lot on their plates, and there are a few legislators who are versed in well-being. And frankly, for many legislators, divorce reform, custody reform is not on the top of their agenda. This is not something that's really on their radar. That's one of the reasons that one of our tasks is to educate legislators about these issues. And finally, it's important to note that the shared parenting movement is a true grassroots movement. We don't have powerful economic forces behind us. We don't have corporations backing us or large, well-funded public interest groups backing us. It is mostly a matter of parents, adult children of divorce, grandparents who go in and talk to legislators and function as citizen lobbyists. National Parents Organization, for example, is an almost entirely volunteer organization. We have one regular paid employee. So we aren't able to hire an army of lobbyists to go in and be pressuring legislators over and over again. So those are some of the structural barriers, the sort of institutional inertia barriers that we have here. But I want to spend more time talking about the special interests. And first, I want to talk about the special interest of judicial associations and bar associations. And again, I want to underscore, this is not to say that all judges oppose presumptions of shared parenting. Many judges support it. It's not to say that all attorneys oppose it. Many attorneys support it. But we often find ourselves opposed by judicial associations and bar associations. So judicial associations will often say that the courts are doing a whiz-bang job right now of determining custody, and there really don't need to be any changes. And really creating a presumption of equal shared parenting would be applying a cookie-cutter approach, a one-size-fits-all approach, and courts should just be as free as possible to do whatever in their judgment is in the best interest of the children. In Ohio, when some shared parenting legislation was being debated, we had a former justice of the Ohio Supreme Court who came in and testified that 50-50 parenting time was unnatural. That will strike many people as an odd claim, including me, because I did 50-50 custody, physical custody of my children, and I never felt that my ex-wife and I were doing anything unnatural when we did that, nor did our children think it was unnatural. But judicial associations and their representatives will often come and oppose presumptions of shared parenting. But these are all judges and judicial associations that haven't had experience with shared parenting. So let me quote from a family law judge in Kentucky, Judge Micah Pence, who said this: "I can tell you that all of us as judges were hesitant about 50-50. I can honestly say I love it. It's a starting point only, and then we maximize the time with each parent. Moms receive a lot of criticism in general, and the standard every other weekend with dad makes moms feel as if they are a bad parent if the father received more than that. And society views the mom in that way. A mom that works as a nurse or another job that requires irregular shifts and therefore needs dad to help more, or just believes 50-50 is best, is seen in society as a bad mom because she doesn't have her kids as often. That stigma has all but disappeared since the 50-50 presumption was put in place. It truly is a fair starting place. Going in biased to one side or the other and making it a zero-sum game just isn't fair to the kids. So that's a judge who was skeptical of a presumption of 50-50 parenting time and came to, as she says, love it. That's an anecdote. That's an individual case. What about the data? Arizona has a strong shared parenting law. It was passed quite a while ago, about 10 years ago now. It's not an explicit equal shared parenting law, but it says that the courts will devise a parenting plan that maximizes the time the children have with each parent. And Professor William Fabricius, who is not only a professor of psychology at Arizona State University, who's done some of the leading research on shared parenting, but also was one of the forces that really persuaded the legislature in Arizona to adopt these presumptions of shared parenting. He did a follow-up study with a number of his colleagues in 2018 about the attitudes that divorce professionals had about the Arizona shared parenting law. And what he found was that the majority of judges think it is a positive change in Arizona law, and they think it has a positive effect on child well-being. What about attorneys? Well, bar associations frequently oppose presumptions of shared parenting. There are a few things to say about that. One is lawyers are experts in family law. They're trained in that. But they typically have no training in child development and no professional expertise on child well-being. So we should listen to them about the structure of the law. But if we're focused on the question of what laws produce the best outcomes for children, we need to look to the experts on child well-being. And those are not lawyers. Those are psychologists, social workers, economists as well, study this, etc. Another thing to note is that lawyers have a financial interest in contested divorce and custody cases. When divorce involves contested custody, it is an expensive proposition. It can easily cost the family $50,000, $100,000, $150,000, and of course, much more for high-income families. And that money doesn't go nowhere. It goes somewhere. And so lawyers have a vested interest in contested divorce cases. And finally, I'd point out that Professor Fabricius' study about divorce professionals' response to the Arizona shared parenting law showed that the plurality of Arizona's family law attorneys supported the shared parenting presumption. That is to say, more of them supported it than opposed it. There were some that were indifferent, hadn't made a judgment about it, but more attorneys supported it than opposed it. So there's a lesson in this, and that's this. Well, judges, judicial associations, attorneys, and bar associations often oppose presumptions of equal shared parenting when they're proposed. The research shows that once it's in place, these groups support the changes, at least by a plurality. What about the domestic violence organizations? Well, we have found that sometimes domestic violence organizations oppose presumptions of shared parenting. They argue that those presumptions force victims of domestic violence to continue to interact with their abusers, and they risk harm to children. And they often do this by telling a true and truly horrible story of when a parent has abused the other parent horribly or abused the children horribly. And they use this to argue against presumptions of shared parenting. Now, NPO believes that intimate partner violence, domestic violence, and child abuse are very serious matters. And it's vital that we treat them seriously with careful attention to the evidence and not use them as a political cudgel to advance special interests. Let me just say a bit about the prevalence of intimate partner violence. According to the Centers for Disease Control, 1 in 5 women and 1 in 7 men report having experienced severe physical violence from an intimate partner in their lifetime. And that's a closer gap, I think, than many people who haven't looked into the research would have guessed. 1 in 5 women and 1 in 7 men. And this serious intimate partner violence results in harm. So 75% of female survivors and 48% of male survivors of intimate partner violence have some kind of injury related to that violence. 1 in 5 homicide victims are killed by an intimate partner, and half of female homicide victims in the US are killed by a current or former male intimate partner. So these are very serious issues. They're very severe harms that people experience. And of course, we need to pay attention to minimizing these harms. While some opponents of legal presumptions of shared parenting raise concerns about domestic violence and child maltreatment, the evidence seems to contradict the claim that presumptions of equal shared parenting put people at risk. In fact, the evidence we have shows that shared parenting reduces intimate partner violence and child maltreatment and intimate partner homicide as well. So what evidence do we have for that? I said that NPO is a research-based organization, and here's some of the research that supports that claim. In 2018, led by the National Parents Organization, Kentucky became the first state to have an explicit presumption of equal shared parenting. Remember, I said the Arizona presumption is not explicit, though it is functioning as an equal presumption of equal shared parenting. NPO led Kentucky to become the first state with an explicit presumption of equal shared parenting in permanent orders when parents divorce. According to data from the Kentucky Administrative Office of the Courts and the U.S. Census Bureau, the incidence of domestic violence cases per 100,000 people has dropped since the enactment of equal shared parenting. And here's a graph showing that. So you'll see in 2018, the presumption was passed. It became effective then in 2019. And the incidence of domestic violence dropped. Now, this is just one state. We only have a couple of years, and there is some potential influence of the COVID pandemic on the data here. But we have more evidence from Kentucky to look at. The Kentucky Administrative Office of Courts was asked, and this is actually by Emma Johnson of the Moms for Shared Parenting organization, was asked to cross-reference domestic violence and family cases with, domestic relations and family cases with domestic violence cases. So we're asking, in how many cases where you have a family going through the family law situation, is there also a domestic violence case? And the data from the Kentucky Administrative Office of the Court shows that this dropped by half between 2017 and 2022, from 988 to 454. These rates were dropping before the enactment of the shared parenting law, but they continued to drop and drop more precipitously after it. And here's a graph of that with the red arrow showing when the presumption of equal shared parenting was passed for temporary orders and then later for permanent orders. Now, again, this is just one state. We would love to have more evidence. And here it's still just a matter of a handful of years. But we do have better evidence, and that evidence comes from Spain. Spain provides for us a natural experiment in the effects of presumptions of shared parenting on the incidence of intimate partner violence. And here's why. Between 2009 and 2011, 5 Spanish regions enacted legislation that increased shared parenting fourfold within 5 years. So researchers looked at Spain and the incidence of intimate partner violence in the regions that had enacted these presumptions of shared parenting and compared those to the regions that had not enacted the presumption of shared parenting. And what the researchers found was truly stunning. This is a direct quote. The policy of shared parenting significantly decreased domestic violence. Survey data indicates that intimate partner violence falls by almost 50% after the policy change. And this is their chart. This is the graph of the data. The red horizontal line there shows the incidence of intimate partner violence in those regions of Spain that did not adopt presumptions of shared parenting. The blue line shows the incidence of intimate partner violence in those regions that did adopt it. Truly dramatic difference between these regions. And you'll see before the change in the law, these regions were pretty much in step with one another about their incidence of intimate partner violence. Now, this refers to non-extreme and the researchers meant by that non-lethal intimate partner violence. It could be pretty extreme by any other standards, but non-lethal intimate partner violence. What do they find about female homicide? They found evidence of significant reduction in the number of female homicides committed by the current intimate partners after the reform. So the current research we have indicates that far from provoking intimate partner violence, presumptions of shared parenting are part of an effective strategy for reducing it. What about child maltreatment? Well, domestic violence groups sometimes imply that presumptions of shared parenting are dangerous for children too. To test this claim, NPO conducted 2 studies. One of those compared Kentucky, which, as I said, has adopted a very strong presumption of equal shared parenting, with Ohio, a neighboring state which has no such presumption. A second study compared the rates of child maltreatment in Ohio counties. It compared those counties that have, at a county level, a presumption of equal shared parenting with those counties that have the old every other weekend, one evening a week schedule. So what about the comparison between Kentucky and Ohio? Well, according to data from the U.S. Department of Health and Human Services, Ohio's incidence of child maltreatment between 2017 and 2021 dropped by 2.5%. That sounds good until you see that Kentucky's incidence of child maltreatment fell by over a third, by 33.2%. That's a very dramatic drop in child maltreatment cases in Kentucky compared to Ohio. And this is a graph representing that. What about the study comparing Ohio counties? Well, as I said, some Ohio counties have, at the county level, a presumption of equal parenting time. Most do not. In 2018, again in 2020, and then finally in 2023, NPO graded each Ohio county's parenting time rule. We gave A's to those counties with equal parenting time rules and D's to those counties with every other weekend schedules. And then in 2023, we correlated the county's grades on their parenting time rule with the incidence of child maltreatment cases reported in the Annie E. Casey Kids Count project. And what we found was quite dramatic. The rates of child maltreatment cases, that's cases of child maltreatment per 1,000 children in the population, are very highly correlated with the county's parenting time rules. Those counties with equal or nearly equal parenting time rules have consistently shown lower and declining rates of child abuse and neglect than the state as a whole, and even more so than the counties that have the limited parenting time rules. And here's a graph showing that in the chart below it. The blue line indicates the rate of child maltreatment, that's child neglect and abuse, in Ohio overall. The green line represents the rate in those counties that have an every other weekend and one evening a week parenting schedule. And the red line represents the counties that have equal or nearly equal parenting time schedules. Now, more research on important matters like this is always desirable. We need to do more research. We need to protect victims of domestic violence. We need to protect children from abuse. But NPO is aware of no research showing that presumptions of equal shared parenting are correlated with, much less that they cause increases in either intimate partner violence or child maltreatment. The research we do have shows just the opposite. And when I think of the relationship between presumptions of equal shared parenting and conflict and ultimately violence in some couples, I am reminded of the quote that's been attributed to many different people, very often attributed to Mahatma Gandhi, who said, "If you want peace, work for justice," because shared parenting is actually a way of reducing the conflict between parents and tamping down some of the violence that crops up in some cases. Well, enough on the special interests. I said that another barrier to equal shared parenting presumptions and the practice of equal shared parenting is outdated and poorly designed child support laws. And I want to delve into this in some depth because a lot of people aren't familiar with the child support laws, what they're trying to do, and how they actually try to carry that out. So bear with me. If you're familiar with this, there's a little bit of background material that I'm going to go through first. NPO learned that child support policies and laws were a barrier to shared parenting as we worked with divorcing couples and saw how often people were saying that child support was making it impossible for them to do shared parenting. While child support laws are motivated by the desire to protect children's interests, many of the laws have unintended consequences and they harm children by creating barriers to shared parenting. First, let me back up. I said I'm a retired philosophy professor, and we like to back up and get things from a very distant perspective here. And I do want to point this out. When we talk about child support, our focus is almost always on financial support. But it's worth reminding ourselves that financial support is only one element of what's necessary for children to flourish and to grow into healthy, productive, independent adults. They need love and guidance of their parents. They need education. They need the opportunity to explore many paths, to test out their strengths and their weaknesses, their loves, their passions, and to pursue those things. And those things are not directly related to the financial resources that a family has. That's not to say that financial support is not vital. Of course it is. But we should remember that the ways in which we support children are not limited to financial support. The goal of child support laws is to ensure that children are adequately financially supported. The Federal Office of Child Support puts it this way. The goal is to ensure that children have the financial resources they need to meet their basic needs, such as food, clothing, shelter, and medical care, to help ensure that children have a stable and consistent home environment, to encourage both parents to be involved in their children's lives, and to reduce the financial burden on public assistance programs. To achieve these goals, the U.S. Federal government requires each state to adopt estimates of the cost of raising children. Now, while the federal government requires the states to adopt those estimates, it gives them a great deal of leeway in how they come up with those estimates. And NPO research available on our website has shown that the states have radically different assumptions about the cost of raising children. These assumptions vary dramatically from one state to another, even when the states have very similar economies. But the point here is that this estimate of the child-related costs is then presumed to be the amount of financial child support that both parents combined, taken together, should be paying for the benefit of their children. And most states employ what's called a proportional contribution principle to divide this combined obligation between the two parents. And the proportional contribution principle, as the name suggests, means that the parents have an obligation to support the children in proportion to each parent's income. So we divide this combined obligation between the two parents proportional to their income. Another point, terminological point, stepping back, one that's of particular importance to me. We use the term child support to refer to the funds that one parent transfers to the other parent. That's misleading. That's really inaccurate. If that's what child support is, it would mean that when we had a couple that are living apart, sharing the time with the children and the expenses on the children equally, and have equal incomes, and so they choose not to pay either parent from the other parent, it would imply that those children are receiving no financial support at all. But of course, those children are well financially supported by each parent in their own home. So we should talk about financial child support as the total amount of financial support available to the children. What we typically call child support would be more accurately called the child support transfer payment. Now, why is there a child support transfer payment? Well, in many cases, one parent is bearing a greater portion, or maybe all, of the direct out-of-pocket child rearing expenses. And then it's, of course, appropriate for the other parent to be engaging in a child support transfer payment to help support the children. And sometimes, even if the parents are engaging in financial support of the children equally, they're sharing parenting time equally and dividing expenses equally, one parent may have significantly more income than the other, and it may then be appropriate for there to be a child support transfer payment. So this transfer payment is handled in a sole custody case in the following way. The custodial parent is presumed to expend his or her child support obligation directly on the children, and the state just ignores that portion. And the non-custodial parent is presumed to owe the custodial parent the non-custodial parent's entire portion of the combined child support obligation. What happens in shared parenting cases? Well, both parents are incurring significant direct out-of-pocket expenses on the children. So states have to decide, how are we going to divide this combined child support obligation, this pool of money that we think both parents together should be spending on their children, between the two parents' households. And states do this by adopting what's called a parenting time adjustment. A parenting time adjustment, in some states it's referred to as a parenting time credit or a residential credit, is an adjustment in the amount of child support paid, the amount of the child support transfer payment paid from one parent to the other, based on the amount of time the children are in each parent's care. If all of the resources that are supposed to be spent for the benefit of the children are put in one parent's house, when the children in fact have two homes, then the children are unsupported or not adequately supported in one of their homes. So the slogan is really, child support funds are for the children. Child support funds should follow the children. They should be apportioned between the two households based on expected expenses in each of the households. So the ultimate goal of the child support system is to promote child well-being. Since we know that it's almost always best for children to have homes with both parents when their parents are living apart, child support guidelines should not create barriers to equal shared parenting. Indeed, they should encourage it. But in fact, most states' guidelines create barriers to equal shared parenting. And that's why it's important to look at child support guidelines and reform them. And that's what National Parents Organization did. In 2022, we reviewed the parenting time adjustments of all 51 jurisdictions, the 50 states and the District of Columbia. And we published our report, the 2022 Child Support and Shared Parenting Report Card. This is available on our website. We were guided in this by several principles, and I want to read all of these because they're important core principles of National Parents Organization with respect to child support. First, most obviously, because children of separated parents flourish best when the parents share as equally as possible in the rearing of children, child support laws and policies should facilitate and provide incentives for equal shared parenting. Financial child support is a shared responsibility between the two parents in proportion to their financial ability. So we accept a proportional contribution principle. Child support guidelines should be based on reasonable estimates of child-related costs, expenses. Child support guidelines should divide the combined child support obligation of the two parents between the children's two households based on reasonable estimates of child-related expenses in each household. Child support guidelines should appropriately reflect the economic reality that when parents are sharing physical custody of their children, both households incur direct child-related expenses. And finally, child support guidelines should avoid creating incentives for conflicts between parents. And based on these guiding principles, we developed 8 metrics for evaluating the 51 jurisdictions on their parenting time adjustments. I'm only going to talk about the first 4 of these. They're the ones that are most important in evaluating the parenting time adjustments. The first one is the existence of a parenting time adjustment. Second, what is its threshold? Third, is it continuous or does it have breaks in it? And finally, does it recognize the fixed duplicated costs of shared parenting? And I'll explain each of these briefly. In the US, there are 9 states that have no parenting time adjustment at all. What this means is that a child support obligor who has the children in his or her house 50% of the time will presumptively pay exactly the same amount of child support as a parent who has the children none of the time at all and is experiencing no direct costs. Now, the parent who has the children in his or her house a lot of the time and by guidelines is paying the full guideline child support amount can go to a court and request a deviation. But there are problems with this. Deviations are unpredictable. By definitions, they're deviations from the guidelines. There are no guidelines, and different courts do different things based on the very same fact patterns. So there's no consistency to how the courts handle this. Secondly, they're expensive. For most people, they can't do this themselves. They have to hire an attorney to do it. They're time consuming. They can take months or years to do. And finally, and maybe even most importantly, they generate parental conflict. because you suddenly have one parent going in and saying, yeah, I know the guidelines say I should pay this, and I know the guidelines are presumptively correct because that's required by federal law, but I want to pay less. And the other parent, of course, is saying, no, I don't want that parent to pay less. So this is a recipe for parents to fight with one another. Those states that had no parenting time adjustment got Fs in NPO's report card. And really, it's just unfathomable how anyone could think it makes sense for a parent who's exercising 50% of the parenting time to pay exactly the same amount to the other parent as if they never saw the children at all. It's beyond comprehension why the states would do this. Those 9 states got flat Fs. What about the issue of thresholds? Well, in most states, there's a threshold before the parenting time adjustment kicks in. So it's some states lower and some states higher. The threshold, a high threshold, means that a parent's direct expenses on the child are ignored if they're below that threshold. And furthermore, every state with high thresholds also creates a cliff effect, making small differences in parenting time create a large difference in presumptive child support. And I'll say more about that in a moment here. But first, I want to show the variation in the states about their thresholds. You won't be able to see this in detail, but along the horizontal axis are all of the 51 jurisdictions. And along the vertical axis is the percent of parenting time that the parent has to exercise before the parenting time adjustment kicks in. And what you'll find is that 34 states have a parenting time threshold of 25% or more, 17, 33% or more, 6 have a threshold of 40% or more, and 2 have a threshold of 182 days or almost half parenting time. So in NPO's grading rubric, the higher the threshold, the lower the score they got. We believe that there should be no or a very low threshold. What about continuity? And the continuity question is connected with the threshold problem. Parenting times that are not continuous have cliff effects. And again, what that means is it makes a small difference in parenting time, like one overnight, create a huge difference in presumptive child support. And it's worth pointing out that cliff effects have no economic justification, zero economic justification. There is no reason to believe that a parent who has the children with that parent 121 days is spending a significantly different amount of money on the children than a parent has them 121 days. It makes no sense whatsoever. And most importantly, cliff effects cause conflict between the parents over insignificant differences in time. Because if you create a cliff effect at 120 days, parents or their attorneys will decide it's got to be below 120 days, or the other parents say it's got to be above 120 days. So you create an inflection point where the parents will fight over an insignificant amount of parenting time. And we found that only 6 states have parenting time adjustments that are smooth, that have no cliff effects. Several states have relatively small cliff effects, but 17 states have cliff effects that are larger than 30%. And what that means is that in these states, one additional overnight will make a 30% difference in how much child support is awarded. Finally, we looked at whether states make a reasonable estimate of the fixed duplicated costs of shared parenting. When you're doing shared parenting, there are fixed duplicated costs, bedrooms for the children, furniture, and other expenses that might be in both parents' home. And child support guidelines should recognize those expenses, but they shouldn't overestimate those expenses. And we believe that the appropriate estimate of those expenses is about 28 to 40% of all child-related costs will be duplicated when you do child support, when you do shared parenting. What we found is that 16 states underestimate these expenses, but 19 states overestimate the expenses, making shared parenting more expensive and resulting in higher child support obligations. Now, based on those 4 metrics and the other 4 that I didn't mention, we evaluated the 51 jurisdictions and graded the states. And here's what we found. Here's our grade distribution. You'll see that it is heavily concentrated in the D and F range. The majority of states are doing a very poor job with their parenting time adjustment. That's the grade distribution, and here's the grades for each of the states. All this information is in our report, by the way, and on our website. We also created an interactive map online. That interactive map looks like this. And if you mouse over a state, You'll see what the positive aspects of that state's parenting time adjustment are and what the negative aspects are and why they got the grade. Now, I see we're running short of time, so I'm going to skip over the various myths and truths about shared parenting that I was mentioning. Those were recorded in a separate Families Divided video, and I invite you to look at that if you wish. But I want to talk now about how we can reform the norms of separated parenting, how we can overcome these barriers. And it is really a multifaceted task. We need to engage in education programs, we need to engage in legislative reform, and we need to engage in reforming the court practices. And let me say something about the importance of the education, because even if we got strong equal shared parenting laws in every state, it's important that judges and attorneys and custody evaluators understand the value of shared parenting, because any statutes will allow courts some discretion. And if the judges and the attorneys and the custody evaluators don't understand the value of shared parenting, they'll use that discretion in a way that limits shared parenting. And it's important to educate parents, because even in a state where you have bad legislation on shared parenting, if both parents go in and say, we want to do shared parenting because we know it's best for our children, the courts will generally give them that. So education is a crucial part of it. So NPO engages in educating judges, attorneys, and parents through sponsoring conferences, through providing research on our website, and through providing information to our citizens lobbyists to share with legislators. We are also exploring the possibility of creating continuing education courses for attorneys and judges. We also have sponsored conferences, including international conferences on shared parenting, and we've initiated the Ned Holstein Shared Parenting Research Award. It's named in honor of the founder of National Parents Organization, one of the true champions for shared parenting, Ned Holstein. We also do our own research, and I've alluded to some of that already. The shared parenting report cards we've done, the Ohio shared parenting report cards, the NPO child support and shared parenting report card that we've done. Those are all by way of educating. We also engage in legislative reform, and we've been having success. In Kentucky, as I said, we passed the first explicit equal shared parenting law. We worked with Arkansas Advocates for Parental Equality in 2021 to get their shared parenting law. We collaborated with other groups in West Virginia in 2022 to get their shared parenting law, and in Florida and Missouri in 2023. In Missouri, we have to give great credit to our Missouri chair and national board member, Linda Reutzel, who engaged in a 9-year battle to enact shared parenting and was finally successful just this past summer. We're currently working with legislators across the country, and we're having progress here. So here is a map from 2014. Unfortunately, we changed the way we did our maps, but in 2014, you'll see the dark states are the very bad states, the lighter states are the better states, and the red states are the best, which weren't very good at the time. In 2019, we had Arizona and Kentucky. But today, we have Florida, West Virginia, Missouri, and Arkansas added to the list. And this is what the grades look like. Increasingly better grades, and increasingly we have states receiving grades in the A range. Courts are guided also by their rules. In Ohio, every court has a parenting time rule. And over the past 3 or 4 years now, up to 5 years now, we have managed to encourage counties to improve their rules significantly in ways that have benefited parents in those counties. In 2018, only 3 counties had presumptive equal or nearly equal parenting time rules. By 2020, we had more counties. We had 3 more counties that had joined that. And many counties have added rules that allow parents to consider equal parenting time rules. So these results have been extremely positive. We still have tasks ahead. We need to pass strong shared parenting presumptions in every state. And we're working in a number of states to get those laws passed. We need to improve child support laws in states. And I want to close by acknowledging that this can be a frustrating task. I've been involved in shared parenting advocacy for now 30 years, and there's some times when I get very frustrated with the pace of progress. But I often remember this quote from Jacob Riis, who said, "When nothing seems to help, I go and look at a stonecutter hammering away at his rock, perhaps 100 times, without as much as a crack showing in it. Yet at the 101st blow, it was split in two. And I know it was not that blow that did it, but all that had gone before." And I want to say we are splitting this rock. It took 230 years from the founding of our country to get the first explicit equal shared parenting legislation passed by Matt Hale, NPO's Matt Hale in Kentucky. 3 years later, the next state joined it. 1 year later, the third state joined. And just in 2023, 2 more states joined. We are seeing accelerated progress, and success is breeding success. And I think there's every reason to be optimistic that we will see more and more states joining the Shared Parenting Club and more families not subjected to the parental deprivation that is so common in family courts now. You can follow NPO on our website, on YouTube, on X, as we all now say, formerly Twitter, and on Facebook. Thank you.